Hello, sisters. I'll begin today by providing an update on some recent activities of our chapter. In June, the WDI USA Lesbian Caucus announced its plan to compile a free listing of lesbian owned businesses worldwide as a resource for sisters who would like to hire sisters. That plan has now come to fruition with this week's publication of that resource, which will be periodically updated as new applications are received. To apply to have your own exclusively lesbian-owned business added to our directory, please complete and submit the application form accessible on our website. In other news, there are opportunities this summer for WDI USA to file briefs in 3 different legal cases that will impact the sex-based rights of women and girls. The first 2 cases, West Virginia versus BPJ and Little versus Hecox, center on the constitutionality of laws protecting single-sex sports and will be heard before the Supreme Court, while Doe versus McWanago in the Seventh Circuit Court of Appeals involves a challenge by a boy who thinks he's a girl to a Wisconsin school district over its policy requiring him to use the boys' bathroom or a sex-neutral alternative. However, in order to file amicus briefs in all 3 cases, we need to quickly raise $17,500. If you're able to contribute, please help us present radical feminist arguments to the courts in these cases. Next, I'll report on a horrifying scandal in California that broke last week. In the Los Angeles suburb of Arcadia, a total of 21 children, 17 of them 3 years old or younger, most born to different surrogate mothers, were removed from a couple's home amid an investigation into child abuse. The case came to light after a 2-month-old baby in their care was hospitalized with severe head injuries, leading to police intervention. The children were placed in protective custody after police discovered alarming conditions, and authorities are currently investigating whether the children found at the home were part of a commercial surrogacy scam run by the home's residents, Sylvia Jiang and Gojan Zhuan. I don't know how to pronounce those Chinese names. I'm sorry if I misrepresented them. Arcadia police said that the cameras seized from the property showed the children being emotionally and physically abused by at least 6 nannies, and showed a nanny violently shaking and striking the hospitalized infant on May 5th, resulting in a loss of consciousness. The baby was not hospitalized until 2 days later, after the onset of seizures. Jiang and Wan were arrested on suspicion of felony child endangerment and neglect, but later released from custody pending further investigation. An arrest warrant has also been issued for the nanny, Shunmei Li, who remains at large. Callie Fell, executive director of the nonprofit Center of Bioethics and Culture, said that these agencies are not regulated by any governing body, and while having more than 20 children through surrogates is not illegal, that to me smells of child trafficking. What are the intentions of having that many children at home through these assistive reproductive technologies? One of the surrogate mothers misled by the couple shared a personal account of her experience in an in-depth interview with Ms. Fell, and her testimony is a chilling reminder of how vulnerable children are in an industry that commodifies the womb and puts a price tag on babies. Also in California, yet another concerning bill is currently making its way through the legislature. As Women Are Real summarizes in its opposition letter addressed to the Senate Health Committee, AB 1084 creates a legal path for individuals, including those with violent or other criminal histories, to erase their public identity without oversight. It opens the door for children under state supervision to undergo legal sex changes without either parent's consent. It eliminates the court's ability to assess motive, fraud risk, coercion, or long-term consequences. Last week, I mentioned the Department of Justice press release announcing that it had recently sent more than 20 subpoenas to doctors and clinics involved in performing sex trait modification procedures on children. Since then, at least 4 hospital systems have either limited access to such treatments or ended their so called gender affirming care programs entirely, while none have publicly acknowledged receipt of a DOJ subpoena as the rationale for their decision to scale back. All appear to have recognized the escalating legal and regulatory risks imposed by Trump's Executive Order 14187, which threatens the loss of federal funding to institutions that continue to conduct these harmful medical experiments on vulnerable minors. The latest institutions to have either restricted access or entirely eliminated the provision of such services to kids includes Chicago's Rush University Medical Center, Children's National Hospital in Washington, D.C., Nemours Children's Hospital in Wilmington, Delaware, and just yesterday, the University of Chicago Medicine Comer Children's Hospital. They join other facilities across the country that have made similar decisions in recent months, citing similar fears of funding cuts. Additionally, on July 17th, the National Review reported that the Department of Health and Human Services will soon begin the rulemaking process to prohibit the federal government from directly funding sex trait modifications for minors through Medicaid, and the Children's Health Insurance Program, or CHIP, which could have drastic financial consequences for hospitals that do not change their policies. Also on July 17th, Puerto Rico's governor signed a bill into law banning puberty blockers, wrong sex hormones, and gender related surgeries for youth under the age of 21 and calls for 15 years in prison for any violators, as well as a $50,000 penalty and the revocation of all licenses and permits of medical staff. And as Jamie Reed notes on X, it's the first ban that goes up to age 21. And finally, I'd like to close by speaking a bit more about the recent, highly impactful public workshop titled The Dangers of Gender Affirming Care for Minors, hosted by the Federal Trade Commission, the agency tasked with protecting consumers. As I mentioned last week, panelists included doctors, medical ethicists, whistleblowers, detransitioners, and parents who all shared their perspective grounded in research, expertise, and personal experience. The event brought them all together with federal officials who argued that gender affirming care for minors constitutes not only medical malpractice, but a coordinated deception of the American public, and framed pediatric gender medicine as a crisis of both ethics and enforcement. Speaking to what comes next in his remarks, FTC Chairman Andrew Ferguson announced that the agency is preparing to publish a public request for information on the various topics discussed at the event to investigate whether gender clinics, hospitals, and advocacy organizations may be violating federal law by engaging in deceptive trade practices, including misleading patients and families about the risks, reversibility, and scientific basis of transition-related treatments. As Matt Osborne wrote in his excellent summation of the event, the FTC is empowered to use compulsory process and subpoena records. They can pursue court injunctions wherever they determine a fraud has taken place. But the Department of Justice has the power to put people in prisons. So the presence of DOJ officials at the workshop is a tantalizing sign of things to come. Indeed. Or as Real Clear Politics puts it, as debate intensifies over the ethics and oversight of gender medicine, the FTC's involvement signals a new front in the legal and regulatory battle. Whether the agency ultimately moves to prosecute deceptive practices remains to be seen, but the workshop marked a turning point, elevating concerns once confined to whistleblowers and dissident doctors to the highest levels of consumer protection. And that's all I have today. Thank you.